Good morning. The purpose of this hearing is to explore whether the experience and expertise of the Army Corps of Engineers provides support for the recently finalized rule that changes the regulatory definition of waters of the United States under the Clean Water Act. Congress has the constitutional authority, indeed the obligation, to conduct oversight actions of executive branch agencies, particularly on issues as controversial as the waters of the U.S., which now is opposed by 31 states. For too long, many of us believe that the Congress has not focused on these important issues and in some ways looked the other way, with executive branch agencies taking actions that do not conform with the law. We are changing that. Oversight is particularly important when we have a pattern of behavior from certain agencies, like the EPA, of consistently issuing rules that completely disregard the limits of their authority imposed by Congress. In fact, on June 26, just 3 days before the Supreme Court overturned the EPA's mercury and air toxic rule under the Clean Air Act, EPA Administrator McCarthy literally bragged on TV and an HBO show that the Supreme Court's decision ultimately would not matter because it took 3 years to get to the Supreme Court, and by then, most people subject to the rule would have to abide by it anyways. Investments have already been made, she said. This is in addition to an agency that consistently loses court cases in the Supreme Court, and constituents, certainly across Alaska, but I think all across America, Democrats and Republicans, believe that the EPA is a rogue agency accountable to no one. We see it in my state on issues like CD5, GMT1, where other agencies are told by the EPA what to do. Now, I have the utmost respect for the Corps of Engineers. I've worked with them for years, the civilian and military members of that organization. But the arrogance and disregard for the law that is evident in the WOTUS rule is something that is imperative that the Congress conduct oversight hearings with regard to that rule. It's no secret that many of us think that the final WOTUS rule goes far beyond the authority granted by Congress. At a hearing back on March 4th, I asked Administrator McCarthy for her legal analysis that supports the rule. There was no response. On July 14th, the chairman of this committee, Chairman Inhofe, and my Republican committee colleagues joined in a letter, again asking for the legal analysis of the WOTUS rule. No response. We received nothing. All of my colleagues, whether Republicans or Democrats, on this committee and in the United States Senate, should be concerned about such arrogance with regard to our constitutional duties to conduct oversight of this agency. Today we are focusing on the factual record for the WOTUS rule. Whatever your views on the limit of authority under the Clean Water Act, we should all be able to agree that an agency rulemaking must be supported by a factual record. This might sound like a technical issue to some, but it is not. In numerous places, the preamble of the final WOTUS rule states that the rule's requirements are based on the science, agency expertise and experience, and case-specific jurisdictional determinations. To understand what documents the preamble is referring back to, in July, Chairman Inhofe sent a letter to the EPA asking copies for the scientific studies that agencies relied on with regard to supporting this rule, and a letter to Secretary Darcy asking for examples of the case-specific determinations the agencies relied on. EPA has not yet identified any specific scientific studies in response to Chairman Inhofe's letter. We are awaiting a response, as well as a response to our long-standing requests for legal analysis before scheduling a hearing with the EPA. Secretary Darcy has responded to Chairman Inhofe's letter by candidly admitting that the WOTUS rule is not, I repeat, not, based on the case-specific jurisdictional determinations of the Corps, even though the preamble to the rule makes that claim. She had to make that admission because, as we now know from memoranda prepared by Corps career staff that have been provided to the EPW committee, case-specific jurisdictional determinations that provide a basis for the WOTUS rule do not exist. I would hope that all members of this subcommittee agree that when agencies make claims about a rulemaking record that are flatly contradicted by senior staff within an agency, that is a cause for concern. That is a cause for concern on how our federal government functions. That is a cause for concern that is worthy of the oversight of this committee. In fact, it strikes at the heart of the integrity of the rulemaking process and, I believe, our representative form of government. I am not talking about legal interpretations or policy disputes. What we are focused on today are statements that the agencies presented as facts that, according to memorandum written by technical experts in the Corps of Engineers, are simply not true. I understand that this hearing puts Secretary Darcy in a somewhat awkward position, and I appreciate her willingness to testify today. We recognize that the EPA may have been in the driver's seat in developing the legally questionable WOTUS rule, but Assistant Secretary Darcy signed the rule along with Administrator McCarthy. She, as well as the EPA, is responsible for the veracity of the claims that the rule makes that is of concern to literally millions of Americans right now. I was surprised to learn of the degree of conflict between the two agencies. To me, this is further confirmation that the EPA is truly an agency that answers to no one, and that needs to change. I appreciate Ms. Darcy's willingness to do the right thing by sharing those memorandum with the committee as part of our oversight responsibilities. I also appreciate her willingness to appear before the subcommittee, a committee that she knows well, to discuss the Corps' participation in the waters of the U.S. rule. Finally, I want to remind her, respectfully, that we expect her to be candid in her answers. This subcommittee will not accept any attempts to evade answering questions based on claims of executive branch confidentiality interests, deliberative process privilege, or ongoing litigation. While these excuses may work in responding to FOIA requests or in defending litigation, they are not the basis of withholding information and truthful answers from the Congress of the United States. It is important that Congress hear directly from you, Secretary Darcy, about why the views of your technical experts at a very senior level, as we all know, were largely ignored, and why the record of the WOTUS rulemaking and the Corps memos contradict statements made in the final rule published to the American people. I am placing the Corps' memos in the record for this hearing without objection. So ordered. Thank you, Secretary Darcy. And look, let's just, for the record, we do this every time in this committee. We all want clean water. My state has the cleanest water of probably any place in the world. And to be perfectly frank, it's not because of the EPA. So we all want clean water. We know that. But we also want agencies that are accountable to the people and to this body. So let me just ask the very obvious, important question. You've seen the memos from Major General Peabody, and these are not small-level EPA Corps officials. Again, I have the utmost respect for the Corps. These are well-thought-out memos, and I'm just going to read a couple excerpts from these memos. The April 27th, and these are right at the moment in which the rule is going to be finalized. So these are big, big disputes from a key agency, not just any agency, a key agency with regard to WOTUS. The April 27, 2015 memo to you said, talking about the preamble and the rule, states, quote, those statements where you guys supposedly are supportive of the rule are not accurate with respect to the draft final rule, as the process followed to develop it greatly limited the Corps' input, a practice that has continued thus far in the interagency review process. The May 15th memo, the documents can only be characterized as having been developed by EPA and should not identify the Corps as an author, co-author, or substantive contributor. The Assistant Chief Counsel for the Corps. It will be difficult, if not impossible, to persuade federal courts that the implicit effective determination that millions of truly isolated waters do not in fact have a significant nexus with navigable interstate waters. Consequently, the draft final rule will appear to be inconsistent with the Supreme Court's decision in Rapanos and Swank. This is why we've been asking Secretary or Administrator McCarthy for the legal opinion, which she refuses to give us because of concerns like this. Finally, on 15 May, a few weeks before the final rule was promulgated, quote, this is from, again, General Peabody, quote, to the extent that the term agencies includes the Corps of Engineers, any such reference should be removed. Finally, the Corps of Engineers logo from the final rule should be removed from these documents. You have said the final rule represents the Corps and EPA's experience, the Corps' support. These documents dramatically tell a different story. Who are we supposed to believe? Where are the documents to support your claim that the Corps supported the rule? And did the EPA pressure you, as the head of the Corps, to sign the final rule when your senior leadership obviously wanted nothing to do with it?
I was under no pressure to sign any rule, Senator. This has been a collaborative joint development of this rule starting several years ago.
Can you explain the response? These are dramatic documents. The senior-most officials in your agency were essentially saying, the rule is untrue. We want nothing to do with it. Take our name off it. Literally, take our name off it. We do not support it. We think it's against the law. How do you respond to that? And this is on the eve of the rule. How do you respond to that?
Senator, those documents and those memos were a snapshot in time.
No. They weren't a snapshot in time.
Senator,
they were at the end of a long process by which several agencies, and again, let's face it, it's the EPA, and the Corps is the key agency here, the key agency. This was not a snapshot in time. This was at the end of years and months of working on this rule. Your final civilian leadership and military leadership said, we've had nothing to do with this. We don't agree with this. Literally take our name off it. How did you then ignore that advice? I mean, literally, the rule was issued about a week later. Not a snapshot in time. We're not going to buy that.
Senator, those comments were on the draft final rule. The final rule that was published reflects some additional changes to the proposed and the draft rule, that some of which the comments in those memos have been addressed.
Some,
yes, sir.
But not all.
Yes, sir.
And again, I don't see how you can claim that the Corps even supports the rule and the technical aspects of the rule, and the administration, according to its brief in the Sixth Circuit, opposing the motion by 18 states that are now challenging the WOTUS rule. We're talking about the technical support documents, quote, the TSDs, that explains that, quote, the agencies are using their technical expertise to promulgate a rule that draws reasonable boundaries in order to protect the waters that most clearly have significant nexus while minimizing the uncertainty of the scope of the WOTUS rule. Then DOJ argues that the technical and scientific determinations should get the highest level of deference, which is normally the case in a Chevron litigation. But that might be true if the record to support those technical determinations came from the Corps. The only technical determinations in the record are statements in the technical support document. But according to the Corps, this is a quote, the Corps was not part of any analysis to reach the conclusions described. This is a quote from your agency. Let me say that again. The Corps was not part of any analysis to reach the conclusions described. Therefore, it is inaccurate to reflect that the agencies did this work or that is reflective of the Corps' experience or expertise. This is incredibly, incredibly damning. The Justice Department can't rely on this agency deference when the agency itself is saying it had nothing to do with it. How do you respond to that?
Senator, the agency had some input into the
Not according to this memo. Can I repeat that? The Corps was not part of any type of analysis to reach the conclusions described. Therefore, it is inaccurate, so please don't be inaccurate with us, to reflect that the agencies did this work or that is reflective of the Corps' experience or expertise. Your senior people, who are probably closer to this than you are saying you had nothing to do with it. So be careful when you're telling the Congress of the United States that you did, because right here in writing, there's a memo saying you didn't.
Senator, you're referring to the technical analysis. Some of the information that was included in the analysis was provided by the Corps. The Corps did not do that analysis. That's correct.
So, Secretary Darcy, thank you for answering the questions and being the sole witness at this hearing. It's an important hearing, and I'm going to address a little bit what Senator Cardin had mentioned. Hey, what is this about? It's about oversight. But let me ask a couple additional questions here. There's kind of a theme, and Senator Markey was focused on it. That hey, look, this is policy, internal policy debates. You're kind of making the same kind of narrative here. We understand when that's the case, right? Agencies have internal policy debates. There's a pushing, toing, froing on what the right decision is. And when that happens, Senator Markey used the term balance of views, policy discussion. You're kind of insinuating, hey, there's reasonable alternatives here that we had the option to deal with. And I think that sounds good. I think what is really concerns so many of us is that it's actually not true. It's not true. This is not one of those examples of, hey, on the one hand, on the other hand, and let me give you just a few. There's a lot. I'll just mention a few. In the May 15th memo from the Chief of the Corps Regulatory Program, he stated to you, so this is like two weeks before the final rule is going to be issued, quote, "It is patently inaccurate." Okay, this isn't black, this isn't gray. It is patently inaccurate because both the final rule states that the rule does not have any tribal implications. That's in there. He states that is patently inaccurate because both the expansion and loss of jurisdiction of the waters of the U.S. may have significant effects on tribes and their resources. And certainly in my state, like Senator Fisher, I held a hearing on the WOTUS rule in Alaska, and one of the most powerful witnesses was the mayor of the North Slope Borough, saying that this would have an enormous impact on their borough, tribal entities on the North Slope of Alaska. Enormous. So this isn't kind of a balance, hey, maybe we got it right, maybe we got it wrong, I'm going to thread the needle here. Patently inaccurate. Let me give you another example. In the April 24th, 2015 memo, quote, "Arbitrary limits within the definition of neighboring," when he's talking about the extent of the rule, "are not rooted in science and beyond the reasonable reach of defining adjacency by the rule." So these are your experts who I assume have a lot more expertise on the science than you do. And they're not low-level guys, they're senior guys. And they are saying that the limits you're defining in the rule are not rooted in science. There's a lot of talk on this committee about, hey, we got to base things on science. Your experts, and again, this isn't black and white. They're saying this is not rooted in science. Let me give you a third example. This relates to the issue of adjacent waters, where the final rule automatically regulates all waters within 100 feet of a tributary or other water, and all waters within 1,500 feet of a tributary or other waters if located in the 100-year floodplain. Okay? The final rule in the preamble says, quote, "The adjacency provision," which your experts said was not rooted in science, "is based on the best available science." That's what the preamble of the rule says. Your top scientist and expert, probably a lot more experience than you do, says that's not true. The adjacency provision is based on the best available science, the intent of the Clean Water Act and case law, and is consistent with the experience of the agencies in making case-specific nexus determinations. So that's what the rule says. So, again, General Peabody comes back to you and says, actually, that's not true. Based on how many feet there are between bodies of water, it cannot be based on the Corps' expertise and experience because the Corps does not record distances in their jurisdictional determinations. So again, you have a senior expert who is saying it's not true. So this narrative that, hey, it's kind of we're threading the needle, one side is saying one thing, reasonable people can disagree. You're senior people, and this wasn't a snapshot in time. This was at the end of a years-long process with the top experts in your agency. They're coming out saying, this is not a gray area. Make the call, Madam Secretary. You're the political leader. They're telling you it's black and white. They're telling you it's black. You're saying it's white. That's why we're so concerned here. That's why we're so concerned here. How do you respond to those? How do you respond to the patently inaccurate? May 15th. Your top expert says that the rule says this is not going to have any tribal implications. He comes back and says, that's patently wrong. How do you explain that? How do you then go, nah, you're wrong. I'm right. How do you do that? I'm just curious because it seems to me this is not a judgment call. This is not a policy call. This is black and white. Your senior people are saying black. You're saying white. I think because you're being told by the EPA to do that, but you've said that you weren't. So how do you explain that? How do you explain these other ones? How do you say that it's based on science when your top officials who knows the science probably better than you do says, no, don't say it's based on science because it's not. How do you explain those away?
Senator, the adjacency determinations are based on science.
And the general said, quote, arbitrary limits within the definition of neighboring are not rooted in science, unquote.
The definitions for neighboring as well as adjacent were based on the connectivity report that the Science Advisory Board provided, and there needed to be a decision made as to where the bright line would be drawn as to what was going to be jurisdictional and considered to be an appropriate water body to be considered for significant nexus test.
Are you more of an expert? Are you more of an expert on these issues than General Peabody or the people who drafted those memos?
I don't believe that I'm more of an expert. I believe that it is my responsibility in the position where I sit that I have to make decisions as to what should be included in the rule in order to carry out our obligations under the Clean Water Act.
So you have the authority of as a political appointee to look at your folks, not on a judgment call, but just saying, hey, General, I know you know more about science than I do, but you're wrong, I'm right. I think Senator Inhofe made a really good point that it seems like everybody's wrong with the exception of you in this case, and the EPA.
I don't believe everyone's wrong. I believe that if there is a difference of opinion and it is my responsibility to make a call, that's my job.
Let me, and look, I'm not trying to badger you here, but there's a broader issue at play. It's the issue of what I'm sure you're familiar with, what's called Chevron deference. And the Congress, through the courts and the Supreme Court and through our roles here, provides agencies a lot of deference. We do it in in laws. I actually think we do it too much. The courts certainly provide that deference, that Chevron deference to agencies. And so when an agency makes a call and it's reviewed by a court, the court says, hey, we're going to give the agency deference because we know that the rule was based on the unique expertise and experience of the agency. That's what Chevron deference is, isn't it? That's
Yes.
why your rules are not considered arbitrary and capricious, right?
Correct.
But the problem here is that we have memo after memo from the top people in your organization saying this was not based on our expertise or our experience. And so it kind of undermines the whole idea of Chevron deference that we grant to agencies like you. And that's why I think you're going to continue to lose in the federal courts, because if the rule's not based on the expertise and experience of senior Corps officials, you may have made the call that black is really white when your team's telling you that's not the case. But I think you're going to have a hard time convincing a court that you deserve Chevron deference when the expertise and experience of your agency, according to your own experts, was not part of this rule. Do you have a comment on that?
The final rule is based on the Department of the Army's being the agency. The fact that the memos are now part of the public record in some of the court cases that are being developed, I will await to see what the courts do as far as Chevron deference with regard to those memos.
Okay, it's a very serious issue, and that's why we're holding the hearing. Let me just ask a final question. You know, there's a lot of concerns on the federal regulatory process. I think we in the Congress need to do a lot more in terms of oversight on this process, whether it's in the development of rules, and this is what we're focused on here, the development of rules, whether it's in the legality of rules, and not the Corps, but the EPA, 2 Supreme Court terms in a row, big rules that they've issued, the Supreme Court has said have violated the Clean Air Act. In the application of rules, and in a stunning statement, and I mentioned at the outset, but I'm just stunned by it. The administrator of the EPA essentially said, hey, whether we win or lose in the Supreme Court, it doesn't really matter, because those American people who they're supposed to be represented, that we represent, they got to do what we say anyways. And I'm amazed that my colleagues on the other side of the aisle don't look at that statement by the EPA administrator and just drop their jaws in shock. That is the most arrogant thing I've seen. Do you agree with that? Because right now, WOTUS, there's a lot of people who don't like WOTUS. There's a lot of problems with WOTUS from a legal perspective. The Corps even said so. Again, I read the memos. They think it's not going to pass muster. Of course, the administrator thinks it does, but she probably doesn't even care, because millions of Americans are going to have to abide by it before the Supreme Court finally rules on it. Do you think that that's the way the regulatory system in America should work? And do you think the administrator's comment that drips with arrogance about what her role in the federal government is, you think that's appropriate?
I believe the administrator was commenting on her situation, and my comment here on the waters of the U.S. rule is that we are acting within the legal framework that we have been presented with, partly because the Supreme Court recommended that the Department of the Army and the EPA develop a rule under this Clean Water Act. And that's what we've done.
Your own chief counsel thinks that this is likely not going to pass constitutional muster.
No, sir. My chief counsel believes it does. The deputy chief counsel for the Army Corps of Engineers at that point in time believed it would not.
Okay. Thank you, Secretary Darcy. Appreciate your willingness to answer these questions. This is, as I mentioned, an important issue. Senator Cardin asked, what's this about? This is about oversight. This is about oversight. This is about our constitutional role with regard to agencies. The American people clearly want more oversight of agencies like the EPA. And again, I'm a big fan of the Corps, but on these kind of issues, they're critical. And what's really critical is that the agencies in our federal government take action and promulgate rules that are based on the intent of Congress and statutes. And that's what we're trying to continue to focus on. I think my colleagues on both sides of the aisle would agree with that. And what we're trying to do, and Senator Barrasso mentioned it, if the rules don't do that, then what we should do is work to pass a law. And we are working to pass a law, and we have bipartisan support on a new clean water rule law, and I would encourage my colleagues on both sides of the aisle in this committee to co-sponsor that important piece of legislation by Senator Barrasso. Thank you again. This hearing is adjourned.